If it was not the intention of the parties that time should be of essence of the contract, then the contract does not become voidable. But the promisee is entitled to compensation from the promisor for any loss caused to him by such failure. See, one thing is very clear in either of the situation, whether there was intention of the parties that the time is of essence or whether there was no such intention. In either case, if the contract is not performed by the time specified, there is definitely a breach. As we saw in section 39 also, please remember that breach is one thing, putting an end to the contract is another thing, the contract becoming voidable is another thing. These are three different situations. So as soon as the time limit is exceeded, as soon as the contract is not performed within the specified time, breach has definitely taken place. But the contract can still continue. Let us say the contract is of supply of goods by a certain date. Part of the goods were supplied, but some part was still to be delivered, and the time has come, time has been exceeded. Now, it is the option of the promisee, it is option of the receiver of the goods, whether he allows the contract to continue as such, or whether to put an end to the contract, or whether to declare the contract as voidable. Now, this option of making the contract voidable will depend upon a condition. It's not a sweet will of the promisee. It will depend upon the condition. What is the condition? What was the intention of the parties? It will depend upon the intention. If the intention was the time was of essence, then he can declare the contract as voidable. If this was not the intention, that he cannot do so, though of course since there is a breach, he is entitled to compensation.